Welcome back to Seavine News Network. This is Linda Forsythe.
And I'm Leonard Bacani.
And we are back here on June 20th for an update of the pretrials, the KSM et al. Pretrials Military Tribunals for the week of June 17th. And today we are going to be covering June 17th and 19th. June 18th was closed proceedings. So what we're going to be doing is going to be reading off the actual article that we have on the website here. And so we are going to have links where you can follow along in this article after we get done with this video. And there will be some links to various different articles and other fact-checking things that you can use along with the transcriptions. So let's go ahead and get right started. Oh, by the way, hey, we got Seavine hats.
Hey.
Okay, we had to do this. So we just thought it'd be fun. And, eventually we're going to be offering these on our website, but these were just samples that we were experimenting with. So we decided we're going to try it tonight.
Yeah.
Okay, so I'm going to go ahead and minimize this a little bit so it's not just all us. And you can see what it is we are talking about. And of course, this is there. Oops, there we go. All right. So scrolling down here, the Seavine News Network Gitmo Military Tribunals, June 17th and 19th, KSM et al. Pretrials. The Gitmo Military Tribunal transcripts for 6/17 and 6/19. So you are aware we do have the transcripts here on this particular article that you can go ahead and download and also follow along. Now each transcript, just as a word of warning, is like almost 120 pages. Sometimes they're a little bit longer and a lot of legalese. And so what we're trying to do is trying to make life a little bit easier and just going over the highlights so you know what to skip through. But details are definitely on those transcripts. All right. The transcripts for the military tribunals for the KSM et al. Tribunals and Gitmo are out. Each one is over 120 pages. Sorry, I already said that. We're posting the DoD website links here for you to download each set. This is for the days, and I'm repeating that again. Didn't mean to. All right, our Seavine members and citizen journalists, Bonnie, Nirgude, and Linda Houck, were each trained by us to handle the coverage. And this week was their first assignment. Talking about being baptized by fire, you're going to be finding out, some of the things that went on. We wanted to be there for their first time to kind of hold their hand and help orientate them to things because there's a lot of things to be aware of. And so Leonard and I weren't able to make it this time. And so they were there by themselves. So anyway, so the coverage this week was their first assignment. Be aware that each of them attended and the coverage for you as volunteers and at their own expense. I'm getting used to this mouse, sorry. Okay, there we are. Okay, that being said, we're going to bring to your attention the page for donations on our Seavine website that is attached to our foundation. Please donate generously because the expenses have become quite large. It isn't just because of our monthly expenses, but also going to these tribunals, the hotel bills, the airfare, and food and lodging and everything else is quite bad. So at the very top of our website in the taskbar, you'll see a Seavine donation page. So just click on that, and if you can help, we would deeply appreciate it. Okay, so moving on. These are the links you can see here to the actual 2 transcripts. And so just click on those, download them, and to your computer, and that you will have yours. Now the calendar for this week of June 17th, and it's subject to change without notice. That is one of the things they actually brought up in a couple of days of these tribunals about some of the things that was going on with the calendar, and I think they're going to be trying to make that better. But as of right now, the calendar could change at any time. So for today, even though today is the 20th, we're just going over the 17th for right now, and You can see for the actual day on the 17th, they were going over the preliminaries and the voir dire of Judge Cohen. So, Leonard, tell us what the voir dire is.
Voir dire is actually a French word. It means to see and to speak. And what it is, it's a uh, proceeding in which all the attorneys, both the prosecution and defense attorneys, can ask questions of either witnesses or expert witnesses or jurors or even the judge. And they ask questions as far as his uh, competency and his training experience and all that to see if he's qualified, number one. Number two, whether he's biased and whether he has prejudices. And they can voice their objections if they feel that that judge or expert witness is not qualified.
Well, I'll tell you, the first day was rather uneventful, but there were some pertinent things that did happen. So we're not going to be spending a lot of time on the first day, but to bring up some things of importance. This light in my eye makes it very difficult to see the screen. Okay, when you open up the actual transcriptions, this is what it looks like. And you will notice that it says unofficial, unauthenticated. We do mention this every single time, but just in case you are new, the DOD puts them out like that on purpose, because even though they have been proven to be secure and accurate, there isn't anything wrong with them, but except that they didn't go over necessarily checking closely for spelling, any punctuation or little errors like this. But what is important to have is actually just fine. And when they do have the official ones come out, there isn't going to really be any difference, except there's not going to be any spelling errors. Okay, so as you can see, there is like close to 120 pages on this one. Now, what is really of importance when they started the proceedings, I'm going to be going over some notes that were sent to us by Bacani, Nirgude and Linda Houck. And these are some of the notes that they had here to help cut things a little bit short. Now, there was one thing that was interesting. It says, we have had no 9/11 family members observing this week's pretrial proceedings. That's rare, but has happened. Meantime, up near the Pentagon, the Chief Prosecutor's Office has offered an upbeat assessment of the progress in a report to the victims. Well, there has been some behind the scenes statements talking about that the reason the family members and the victims and also some of the actual victims that showed up are quite frankly fed up. On May 17th, there was a Fox News alert that went out that the family members were, and had many times before, trying to file to have the names released from the taped phone calls that they had almost up to 6 months before September 11th, 2001, that was conducted by the FBI. And those phone calls have had, actually the individuals that were talking on them have been identified by a linguist. And there's things that we talked to you about and told you about in previous videos. So we're not going to go over that here, except to remind you that those are in existence. And the family members have been trying for years, over and over and over again, to get those names released because they know who it is and they know what's going on and so on. And for years, nothing has been happening. So they were able to finally get this in New York, in federal court, have a judge go ahead and rule to be able to open up on who the names were that were identified within these taped recordings. Well, it just happened that when I saw that Fox News release, that alert, I went ahead and I copied the link and I sent it over to Leonard here just to show him what was going on, because it was talking all about how that day they were going to make a ruling. The judge was going to make a ruling on whether or not the names were going to be released. And so I went back to go check it a couple of days later, and not only couldn't I find that particular Fox News release, I couldn't find anything about any proceedings happening anywhere in New York at any time, let alone to find out if a ruling had happened. We had one of our investigators at Seavine, our licensed investigators, look into this, and he looked into it and he couldn't find anything. It was like it was scrubbed, and haven't heard anything anywhere about anything about any of this. Well, to me, this situation here where the family members aren't showing up to these tribunals, one has to assume that they're not there because they're just plain PO'd. And so I don't know what the ruling was, or even if there was one. We'll have to see.
You know, keep in mind that Seavine broke that news where I reported it in front of the White House, and then about the intercepts that the CIA had of the 118 phone calls and 20 out of the 25 lines. We broke that news, and then it just so happens a few weeks later, you had an uprising of victims and their families wanting that information. So was it because of our reporting? You know.
Well, I think they probably knew about it because, you know, it was mentioned years before that, but
Yeah.
it is kind of a reminder. But things are coming to a head, I guess, this, you know, for the most part, what is being said here. Now, the next note I have at the war court, the individuals who are accused of plotting the 9/11 attacks meet their new judge, Air Force Colonel W. Shane Cohen. Judge Cohen, defense lawyers, and prosecutors huddled yesterday in a chambers conference to map out this week's pretrial hearings. Well, to go over last video that we had here on the very last day, the very last hour, the very last sentence, Judge Perella, who was the previous judge who had been on this case since August of 2018, just haphazardly answered a question from Colonel Cannell.
No, that's Jay Cannell.
Okay, who said to the judge that, well, if I don't see you again anytime soon, it's been nice working with you. I hope you enjoy your new assignment. And that was just out of the blue. And Leonard was there that time. He was like, what? You know, there was no warning or anything. And that's how we found out that Colonel Perella was going to be reassigned someplace else in June, this very next proceeding. And so he was, and he has a new wonderful position, and he started with that, and now we have our new judge, which personally I really like. And I am going to click on this here so you can see it. That is the actual biography of Colonel Cohen. And okay, he was the Deputy Chief Circuit Military Judge, Air Force Trial Judiciary Eastern Court Circuit, Joint Base Langley, Estes, Virginia. In this capacity, he served as a trial judge at general and special court martials worldwide. And he entered into active duty in November of 1998. You know, I'll go ahead and leave this up here for you to read. But like I said, I really like this judge. And it was interesting, which you will see is mentioned, that he's not only very polite to everyone that's there, but he's got, everyone is very polite and respectful to him, which is a good thing. A wonderful background and so on. So going over to the next note, the new 9/11 judge, Air Force Colonel W. Shane Cohen, has called his first lunch recess in the case to straddle midday Muslim prayers. Judge Cohen is undergoing defense questioning for bias qualifications in the voir dire. So Leonard already explained to you what that is. So the morning again was pretty uneventful. This was just the beginning. Now, one thing that happened after lunch, there was something that they were saying in the actual proceedings that the judge's name should be made secret. And in the notes here, Carol Rosenberg for the Miami Herald made a notation that I am going to repeat here. In the 15 years I've covered the Guantanamo War Court, for all its pick and choose transparency, no government or military or judicial entity has ever suggested that the military commission's judge's name should be secret. They have, however, increasingly hid juror identities. And so there was a question there, should we keep the names of the judges confidential? Well, I don't know, but that is just something that was brought up today. So also, in that regard, he answered a bit like the last 9/11 judge, Marine Colonel Keith Perella. But Colonel Cohen has a vastly different demeanor. He is exceptionally courteous. He addressed defense lawyers as sir and ma'am and referred to the defendants as gentlemen. Okay, his biography shows that he was an Air Force captain on 9/11. He was just shy of 3 years in service after graduation from Brigham Young Law School. And states, I do not recall ever being angry when questioned about anything that happened on September 11th. Anger is not a word I would say ever manifested itself. And so, but what he did say, he was shocked. And that was the main situation of what he had. And so the defense and the prosecution attorneys continued to ask him multiple questions. And says today's qualifications questioning of Judge Cohen. On September 11, 2001, he was at Moline Air Force Base in Washington, D.C., taking a course for military defense attorneys. And he stated here that he acted with shock. It was not something you expected to see on the TV on that particular day. Also of note in the notes here, they took 2 seats in a section meant for war court victim observers. None came to Gitmo this week, as I mentioned in the beginning. And then they walked out 4 minutes later. So let's see here. Something else of interest, Samar al-Baluchi, who had a cyst burst at the base of his spine in recent days, was allowed in court for about an hour as a judicial accommodation. Mustafa al-Hawasi, who has a long history of rectal pain and bleeding, sat on a special donut pillow as usual. And if you go way back into the proceedings from many years ago, some kind of horrific things through torture that actually happened, and may or may not be coming out specifically now, but it has come out in the past. Also today, the judge released 2 of the 9/11 defendants back to the Camp 7 prison less than 30 minutes into the proceedings at their lawyer's request because each currently has pain while sitting. More from the judge's voir dire, defense lawyers questioning, which resumes this afternoon. Judge Cohen has had an Air Force specialty in environmental law litigation. This summer, he becomes a chief judge of the Air Force Trial Judiciary Eastern Circuit, where he is now deputy. Judge Cohen also said he had attended a meeting of conference at the same time as Colonel Spock was on the USS Cole case, but found the then chief Air Force judge tight-lipped about what was going on at Guantanamo. It was at that time when he was clashing with defense lawyers, he said. And he also mentioned that he reaches mandatory retirement from Air Force in 9 years. Excuse me. Some of this questioning, they're making certain that this judge isn't going to go away in the middle of proceedings anytime soon. And it looks like that he is going to be staying quite a while. Okay. Let me see here. If there's anything else that really is of benefit that you guys can go over. Oh, one thing that was of interest. Here is a notation. Everybody should be able to practice their religion, he says, noting Cohen is a very Jewish name. Harrington returns to the topic of Israel. Judge Cohen says Israel was recognized as a state in 1947, well before I was born. And then he goes on to say that he does have some relatives who are Jewish, but he is not. I am a member of the Church of Jesus Christ of Latter-day Saints. Okay, so on a question from Prosecutor Clay Trivet, the judge says he has no active applications for civilian employment. Just pretty much over the voir dire. They're making certain that there isn't any conflict of interest or etc. And that's what a voir dire is all about. They ask him about all different types of things having to do with torture and his feelings about that. So you can read over in the transcripts if you want the details of that. So I'm going to go on to the next thing here. Also, for your information, I'm going to be putting on here, these are the orders of how he has been applied for the judge for these particular proceedings. Okay, so we're going to go on to the next day because Tuesday was closed proceedings. And then when we went into Wednesday, which was yesterday, scrolling up here.
Keep going.
Okay, I think this is going too far.
Yeah.
Okay, here it is. I got it. I'm sorry, everyone. Give me just a moment. Okay, now this is going on to Wednesday, June afternoon on the 19th. And the notes in place of what they were going to be going over today is the security infrastructure was going to be done in the morning, and then also talking about laptops, and then also witnesses for suppression. Witnesses for suppression is where it really starts to get interesting. And also on June 19th, Military Judge Colonel W. Shane Cohen presided over the RMC, and 803 session was called to order at 0902. Mr. Muhammad, which was present, Mr. Banal Shabi was absent, Mr. Ali al-Balushi was absent, Mr. Hamzi was absent, Mr. Hawasi was absent. Okay.
Well, Mr. Connell, the lead defense attorney for al-Balushi, they call him Mr. Ali, he reiterated to the new judge the standing objection to the anonymous testimony of the linguist. So.
Oh, okay. Sorry. LDC Lead Defense Counsel, Mr. Connell, sir, I just wanted to explain an ongoing question in the Military Commission, which is about an anonymous testimony of the SJA witnesses. Without complying with the MCRE 506, we have lodged an objection. Judge Perello directed us to brief that objection. That's found in the record at AE 603. Judge Perello ruled against us on that objection, and his ruling is found at AE 603C. The Military Commission granted us a standing objection to anonymous testimony by the SJA witness on the basis of MCRE 506, RMC 806, and other authorities cited in the brief. Military Judge Colonel Cohen states, all right, thank you. Mr. Connell, are you asking me then to take a look at that again or just to allow for the standing objection? I just want to make sure I understand what you're asking of the court. Mr. Connell says, yes, sir. Mr. Cohen, Judge Cohen, excuse me, the commission and...
The judge corrects himself, and it shows that he's not fully acclimated to the military commission and the terminology and the nuances that they have.
Yeah, that's true. And, Judge Connell I'm not asking for reconsideration of that decision at this time. I do object to the anonymous testimony of this witness as the previous SJA witness really wanted to orientate the military commission to sort of the state of the situation there and explain my position with respect to anonymous testimony. And then Judge Cohen says, Mr. Connell, I have done so, and I will allow you to maintain the practice of having a standing objection.
And then you had the other attorneys, Mr. Nevin joined the standing objection, and then Judge Cohen acknowledged all standing objections for all the defense teams.
And then Judge Cohen says, okay, for those who have not elected to not join the objection that was previously filed, I will allow a standing objection to remain with respect to all those teams.
The prosecution had written declinations for those accused not present. What that a written declination is basically a waiver that they don't want to be in court, and they have to submit it, a sworn statement to the judge that the accused did so voluntarily.
Okay, and then Judge Cohen says, negative response from all three counsel who are present. I took the head shake as a nonverbal indication of that response, which I was fine with. I just wanted to make sure I recorded that for the record. And then Mr. Connell said, I just wanted to make sure. I know that some judges prefer verbal response. I think that we got into the habit of nonverbal responses because there are 5 of us. But if you prefer, I'm happy to give a verbal response to these questions. Okay, so a lot of these things are kind of mundane, but it's just,
Yeah, on previously, he's new to, the judge is new to the military commission and the acceptable practices, and he's accustomed in his courtroom having all defendants or all the accused present in his courtroom. So when he sees all these defendants not present, he's like, what the heck's going on? So he's kind of getting accustomed to that.
Well, usually it isn't like that. It was just
Right.
kind of interesting and different the last couple of days.
The judge, he seemed to be the kind of judge, and he's interested in not wasting any time and move forward in the proceedings. And he told the attorneys, I think it's important for us to maximize our use of time while we're in the island each and every time. And that may be my intent moving forward. The judge also wanted to be transparent to the public.
Okay, well, likewise, and this is what he says, and this is for the government information. I've noticed that the website containing the unofficial, unauthorized transcript has not been updated in a timely manner. It appears specifically the redacted versions of potentially the last 2 closed MCRE sessions have not been posted in accordance with the AE 5230. I believe it is the right number for that. Trial counsel, although I am not requiring you to post that, if you would please check on that and then have someone from your staff report back to the commissions as to why that is not being done. There may be a reason, and that's fine, but I want to make sure that we're not overlooking the responsibility for us to provide this notice to the public.
We've got good relations with the Department of Defense, and it was Seavine that reported the discrepancy of the dates and times to the Department of Defense. Matter of fact, you made that call, right, Linda?
Well, yeah, they put us at having to be there at 6 in the morning.
Yeah, and then as a result of that, the website, the Department of Defense website was corrected as a result of Linda's correction.
Oh, well, I don't know if it was just mine. He probably had a few other statements made to him. It sounds like it. But there was also a concern that is not mentioned in here that you will see in the transcripts, that they make their changes to the website with 0 notice. People, the defense team, the prosecution, they show up there and they find out it's been canceled or it's been closed or
Right.
or all this different stuff. And it's in the one defense team member, it's like, we've got a lot of things going on too, Judge. So if we could please have a little bit more advance notice, it would be helpful. And I concur.
Linda, you said that you like the judge, and part of that reason is because this guy's straight up. I mean, when defense attorney Mr. Connell corrected the judge with the correct motion number, number, the judge acknowledged his unfamiliarity. And he said, "Thank you very much. I appreciate that. You are correct. It's going to take me a while to become as familiar with all the numbers as you are, but I'll take no offense if either side does exactly just happen to say, actually, Your Honor, I think you're referring to blah, blah, blah." He says he does have a computer with everything on it. So if he's ever doubting what they're telling me, he can always verify it with the computer. But he told the defense attorneys that he appreciates everything, their candor, and both their defense and the government attorneys.
Okay, so he also states.
Well, you know what? The judge also he took charge of this courtroom, and he brings order. Yeah. And go ahead and share what he said.
Okay, so additionally, I intend, so that you are aware of how we'll proceed this morning and throughout the rest of the week, I intend to follow the existing practice of generally allowing only one counsel per team to argue an issue. Oh, thank you. That's been, quite an ordeal in the past, because they all have multiple attorneys. And
well, there are several attorneys for all of the accused, as well as for the government or the prosecution. It used to be that any attorney can jump in and make oral arguments for that particular issue, but no more. The judge is putting a halt to that. He's saying, well, you guys assign one, and that person will be the spokesperson for that particular issue. And in regards to the motion to suppress, Judge wanted each accused to be accorded the rights and privileges as if they were tried separately, as if they were in civilian courts.
Okay, so where are you at? Okay, as noted, and he states and continues, as noted during my voir dire by Ms. Borman in joint trials and in common trials, in the case that each accused shall be accorded the rights and privileges as if tried separately. I take that to heart, and I realize that not in every situation and every accused in this case have the same interest or same fact patterns or those types of things.
So the judge basically, he says each defense team will argue its own motion within the number or the number of that issue.
He also states, I understand that there's going to be overlap. That's inevitable. And that's why I want to make it clear that to the extent there is, I expect both the prosecution and the defense to inform me of when that is the case. And we will make sure that each and every one of the parties get a fair opportunity to address issues, to call witnesses, et cetera, et cetera. Now I'm going to be moving forward quite a bit quicker through this, because a lot of this you can just go over yourself. We're just going over the highlights.
Well, the assistant trial attorney counsel, Captain Hall, says, "May I please the commission," says the motion, "the prosecution seeks three specific things. First, the establishment of new CCTV remote site at the Pentagon as an extension of the courtroom here. Second, the redesignation of Fort Meade as a CCTV site generally, rather than just the individual site or buildings on Fort Meade specific. And third, an updated and consolidated trial conduct order encompassing these changes as well as previous changes in this motion series." This is what really stood out. Captain Hall said, if, for example, demand ticks up as we get to the trial in this case, we need to adapt to that. The convening authority would be able to move to one of these larger buildings without having to come back here and seek an additional modification to the trial conduct order. And a question that you have to ask is, why would the government bring this up if they weren't expecting an influx of accused being tried through the military tribunals? The government is asking for approval for more viewing sites and expand the use of Fort Meade, which, by the way, they house the NSA. So they have some super secret stuff. They want to be able to use the entire Fort Meade base rather than just one viewing area or one building. The defense also supports a more open public trial. Assistant Defense Counsel, Mrs. Rita Rudowsitz, on behalf of Mr. Muhammad, said, "And Your Honor, I'm not going to address and ask you to consider the question of whether it's really an open trial because Judge Pohl had already made that decision. But I do want to point out that this is unlike any other trial."
Okay, where did you read off? Okay.
Yeah.
If I want to go to a trial on a military base or a federal courthouse or a state courthouse, I walk up to the door of the courthouse, I knock on the door, and I walk in. No one can do that here. I can't even do that here. I have to get orders that authorize me to be able to come to this trial, and everyone in the gallery has to do the same. And they have to go through a background check and all of that. So this is not like every other case. And because of that, the policy decisions are important. And I really appreciate Your Honor framing it properly as a public access question, because that's exactly what it is. And the government has made the decision to hold these trials 800 miles from the US border on a remote island. Sorry, not 800 miles, but 800 miles from the place of the attacks. And that was a decision that was made, and it's a decision that Congress has reinforced. And we're kind of stuck with that decision. But the openness and the ability of the public and Mr. Muhammad have the right to an open trial and that is what the issue is here. And I want to remind the court, which I'm sure you already know, that the public access is really embedded in Mr. Muhammad's right to have the access, not the right of the public. I mean, it's a dual right. It's both First Amendment right and public, but also the Sixth Amendment right. And I would also indicate that the Eighth Amendment applies here too, because this is a death penalty trial with heightened accountability. So I would start by saying that we have no objection to opening the Pentagon.
Well, Ms. Radowski brought up an issue of possibly having a tribunal broadcast over the internet so the public has more access. Mm-hmm. And the judge agreed a military tribunal should be more open and asked the government or the prosecution to help make it happen and make it more open to the public. He was not sure if he had the authority to order the government to the military to have the military tribunals more open. Miss Radowsitz, and I said, and I want to draw the court's attention to the Supreme Court case, which is Presley versus Georgia. The court ruled affirmed family members' right to be in the courtroom. And then the judge said,
my initial inclinations to stay within my authority is that my ruling should address, even if I agreed with you, let's say that, or assuming arguendo that I said I agree, why can't the government stream this? There may be lots of reasons. I don't know. That's not before me right now. But assuming for argument that I said that I agree with you, what would my authority to order the relief or the recommendations that you are, as opposed to just saying, look, while I could always put comments in an order, while I recognize that you're increasing public access, you know, the filings should indicate that there might be a greater need for public access. And so I strongly encourage the United States government to consider, you know, moving forward and, you know, to consider alternative sites where in the geographic areas where there seems to be a large percentage of impacted individuals. That would seem to be the extent of what this court could do. Could be highly encourage the government as opposed to order the government, because I'm not sure what my legal authority would be for ordering them to stream it, for example. Can you help me out? Like beyond that, what could I do legally?
Mrs. Radowsitz said, well, Your Honor, I think there is an inherent authority in the commission to have open proceedings. And she reminded the judge that there already was a 40-second delay in the gallery at Gitmo, as well as the viewing site at Fort Meade. And she said, and the military commission has already taken measures to protect national security by having the delay, and that can be done in other sites and through the internet.
Well, Lieutenant Colonel Sterling Thomas said, I rise on behalf of Mr. Al-Baluchi. I made several attempts to attend CCTV sites at the military bases. got credentials, but never actually got to see anything. Very little Gitmo news gets reported on, and the lack of transparency doesn't feel anything akin to justice for the 9/11 families. Oh, I agree. Being able to follow the proceedings remotely on our laptop computers would be a step in the right direction. You know, we've been wondering why, for the most part, Leonard and I are the only ones reporting on these.
Yeah.
And you know, a lot of people in the beginning when we first started didn't even know this was going on.
Right.
And
You know, the Military Commission allows for not only press, but there's several groups that are allowed. Number one, the victims of the families of 9/11, the first responding firefighters and police officers and other first responders who did respond to 9/11, they're allowed to go to Gitmo. There's also a human rights commission. It's headed by a university law clerk. I'm sorry, he's an attorney for the University for Law, and he headed a human rights commission, and they're allowed at Gitmo. But it's basically the same thing on the States. I mean, there's very limited people. People don't go because it's too much hassle. I mean, they have to be credentialed, go through an FBI background check, you know, have their media credential and everything else.
Yeah, we went through all sorts of things. It was quite interesting. Okay, so Lieutenant Colonel Sterling Thomas says, I rise on behalf, oh, I already read that. Okay, and thus, Your Honor, we ask that you grant our motion under the authority under 806C, authorizing distribution of the hearings on a 40-second delay, authorize the Pentagon viewing site, but we also ask that you open all viewing sites to the general public. Judge Cohen is not immediately rule on the expanded viewing sites proposed internet viewing issue.
Right, so what the defense is asking is for more transparency, just like President Trump wanted. They're asking for more viewing sites. They're asking for public access to not be so, harassed and have to go through what we had to go through. Make it available to the general public. And they're telling the judge, Your Honor, you have the authority. Please direct the government to open up these sites because you have the authority.
Okay, so Judge Cohen took up Appellate Exhibit 0621.
This is after the break. They had a break, and then after the break, this is what happened.
Okay. Judge Cohen took up the Appellate Exhibit 0621, which is the defense motion to compel production of discovery related to the evidence provided to the German government. Okay, you want to?
Well, but you know, apparently the German government conducted their own investigation. And the German government does not have a death penalty and does not allow for extradition of the accused who may face possible death sentence. So there's, in those cases, there's an agreement that's signed between both countries saying, you know, if Germany, we will allow you to have this prisoner, however, you can't execute him. If you execute them, then we're not going to release them. So,
what does Germany have to do with this?
Well, read it, and it kind of explains it.
Okay, so on behalf of Mr. Banal Shabi, we seek the production of any agreements, conditions, assurances. I'll say also stipulations on the provision of evidence that accompany the provision of evidence by the German government to the United States government, specifically any of those agreements that would have precluded the use of any evidence to seek the death penalty or before an extraordinary court. And that would be evidence that would be used either directly or indirectly in pursuit of the death penalty. Germany is front and center. The government's allegation, of course, is that Mr. Banal Shabi was part of the alleged Hamburg cell in Germany, and that many, if not most, of the actions they allege he took in this case took place in Germany. So the ties between him and Germany are many. The second thing we know is that evidence was provided by the German government, and the government says much to their in its response to our motion, and it looks like something was redacted there. The third thing that we know, and another redaction, and here's where our knowledge begins to get a little more speculative, and why we need discovery requests in the first place is that the provision of evidence cooperation by the German government was accompanied by some kinds of conditions, assurances, agreement, another redaction. There is a reason I call all these terms, because I'm not sure exactly what it is, another redaction, that evidence would be used directly or indirectly seek the death penalty against Mr. Benel Shabi.
And just a reminder, German law prohibits death penalty and prohibits the extradition to anybody who might face the death penalty.
Okay, and Germany also, by the statements of their own justice ministry in this case, and in the Moussaoui case, the German constitution would prohibit cooperation in securing a death penalty, even to the point of not allowing evidence to be handed over if it could be used for those purposes. So it appears to us that there were agreements in the Moussaoui case. I don't know what the substance of those agreements were, to the extent that the evidence that was provided in the Moussaoui case may be used directly or indirectly against Mr. Benel Shabi, as we put in our discovery request in our motion. I would also seek any agreements as to the Moussaoui. I mean, that would be one level removed from this case, but if that's how they ultimately got the evidence. We know that the German government did its own investigation. We have provided by the government a lengthy summary of a German federal police investigation of Mr. Benel Shabi that was conducted in 2001. You can go online and find press releases of the German federal prosecutors announcing, warrants against Mr. And it's redacted, for Mr. Benel Shabi, and investigations of him, etc. So that's public. We know that was happening very early before the Moussaoui trial. So what I would say is, I don't know what the substance of any agreement. I believe that there was one that it was reported, just like I believe that there was one for Mr. Benel Shabi. We would request, both to the extent that, again, evidence from the Moussaoui case is going to be used in any way, and then redaction. Evidence that was turned over to the Moussaoui case is going to be used in any way for this case. The government says that they don't intend to use any evidence they received from the German government against Mr. Benel Shabi, and I'm glad to hear that, and we will rely on that. The problem is, what is the use of the evidence? They don't intend to introduce evidence. That's fine. They can know that. They can know that, but without us knowing the agreement, anything that they agree to, that might not have been the full extent of the agreement, whether they were going to introduce evidence in their case in chief. And the government could be in violation of agreements in other ways, even if they do not do so.
And the suggestion is that the United States government came to an agreement with the German government that Mr. Benel Shabi would not be prosecuted for a death penalty case, but in fact, the US government intends to renege on that agreement and indeed prosecute Mr. Benel Shabi for a death penalty case.
Okay, is there some of this that I can skip over because it's starting to get a little bit long and they can look at this?
Yeah, they can read it.
Okay, is there anything else in here? Let me see, it's toward the end.
Well, you know what, they basically says they intend to, on behalf of the government, tells the judge, the government intends to abide by all agreements made with the German government. On the other hand, the prosecution argues that any arguments or arrangements between the two countries are not enforceable by the accused in this case. So it's doublespeak by the prosecution.
Well, it's, let me just go ahead and just mention towards the end here, defense counsel, Major Wilkinson, says something very glaring. Sometimes it seems that the only people who do not believe men such as 9/11 mastermind Khalid Sheikh Mohammed should be treated as enemy combatants are in the administration. This was in response to President Obama's effort to move this case to a civilian court with a full set of civilian rights, which led to that indictment that we were talking about a minute ago. That fits in with the signing statement that we gave to you as Attachment B 625E in the aftermath of the 2009 Act, again, that was President Obama objecting strongly to how Congress was forcing this case into a military trial instead of into a civilian one.
Now, what you have to ask is, why did President Obama fight so hard to have these accused in the 9/11 attack to be tried as civilians or in the civilian courts versus military courts, knowing that in civilian courts, the case would have been probably thrown out, all evidence would have been thrown out, and the evidence would find them not guilty. If President Obama had his way, the end result is that the accused would have avoided death penalty and all the accused would have gotten released.
Okay. And I do realize that the first couple of days were rather mundane. You know, it wasn't exactly a lot of excitement. We are bringing this to your attention, exactly what was discussed, because it is information you do need to know. But things are now going to get really interesting, because if you go ahead and look at the schedule, which is way up here at the top, let's see if I can get there quickly. And that is about what went on today and what is going to be going on tomorrow. Now, today, what was discussed is, again, security, infrastructure, and laptops. But again, witnesses for suppression. See that right there? This is where there's been a lot of argument. This is where the victims of 9/11, the family members of, you know, in 9/11, etc., have been fighting for a long time to get these names released. And it was interesting today in court, from what I received with the notes, that there was some anger that was coming out, surprisingly. And quite frankly, I think it's about time. And so I think, I get the feeling that this new judge, Judge Cohen, he, interestingly enough, has been ruling on things either the same day, you know, since he's been on. He's very quick and expedient. So what went on today, what was supposed to be a closed proceeding on the second part of today, he halfway opened up for us. He did not actually rule on whether or not that the suppression was going to be opened up so we could know who exactly was in those taped recordings, and also what was put out on Al Belushi's when he was going through torture, also came out with some names, and there are witnesses and so on. So when we come back, we don't have the transcripts yet for today, but just to give you a heads up, this is where things really going to get interesting, because if this judge rules to open up what the tape phone calls were and the names come out, this is where all the dominoes are going to fall. So that's all we really have to report to you tonight. Thank you for joining us, and we will be back again within the next couple of days to bring up the final updates, and it may be an emergency report.
Oh, right.
Okay, well, good night, everybody.
Night.